Strategic Planning Standing Committee. Can you just take roll call to make sure we have a quorum since I'm not in the room?
Glassbrenner's not present yet. Cosgrove?
Here.
Frank?
Here.
Brewer?
Here.
Fleming will be a few minutes late. C. Juntis?
Here.
Murphy Lopez?
Here.
Daniel Ruderson?
Here.
You have a quorum.
Okay, great. So we got 6 people here. So agenda item number 2, proof of notification. So Ms. Dole, did you properly notify the meeting down on the bulletin board?
I did, and Ingrid just walked in.
Okay, great. Welcome, Ingrid. Thanks for doing that. Thanks for getting the agenda posted. Agenda item number 3 is agenda approval. So we've got an 11-point agenda today.
I'll make a motion to approve the agenda.
Okay, motion by Brewer.
Frank will second.
Second by Frank. Any discussion on that agenda? All those in favor say aye.
Aye.
Opposed say no. Okay, we've got an approved agenda. Agenda item number 4, approval of minutes. I'm looking for a motion to approve the minutes from the February meeting of the committee.
I'll move to approve.
Okay, I think that was Cosgrove.
Second.
And second by Glassbrenner. Any discussion on those minutes? All those in favor of approving the minutes, please say aye.
Aye.
Opposed say no. Okay, so that motion carries. We've got approved minutes. Agenda item number 5, public comments. Is there anyone from the public who wishes to comment to the committee today? Okay, hearing none, we'll go to agenda item number 6, comprehensive plan RFP questions and answers. So we've got let's see, 1, 2, 3, 4, 5 documents in our folders. The first one, the cover sheet, which is 06 comprehensive plan proposals. So we issued the RFP on January 5th. We emailed the RFP to the potential vendors in the chart below, put it on the website. So the RFP is in your folders, and that's attachment A. Last meeting, we answered questions and we issued those in February 2nd. And then we received 2 proposals, one from, I have no idea how to say it, Foth. That's attachment B. And then the other one is from Southwest Regional Planning Commission, and that's attachment C. And then the scoring sheet is shown as attachment D. So now I'm going to admit from the start here, I'm out of town. That's why I'm on WebEx. I'm in Michigan visiting my spouse's family. I did not get my scoring done, probably very bad since I'm chairing the committee. But I just want to let you all know what I did do. I did read through both proposals. And then a couple days ago, when I sent out the agendas, so I'm just going to give you my brief, what I noticed, and I'm interested to know what other people noticed as well. But I noticed with the proposal from Foth, they pitched a price of $113,000.
Yes.
And they were able to complete it within the time period we wanted, which was a year. Southwest Regional Planning Commission pitched that it would cost us $0, that they could use a remaining economic development grant to complete the work, but it wouldn't be completed for, I believe, somewhere like a year and a half from now. So what I did is I called up, I was a little surprised we didn't get a proposal from Redevelopment Resources. Kristen Fish Peterson, they did the Cuba City Comprehensive Plan. So I called Kristen up and I asked her why they didn't submit a proposal. And she said that they had gotten very busy in the lead up to February 16th, but they were still interested in submitting a proposal. I asked about the time period of 12 months that we're hoping for. And she said that she thought that was a reasonable time frame for them. I did not ask what the price would be that they would pitch, but if we extend the deadline, they would be interested in submitting a proposal. And then I tried to write down in this chart on the cover sheet folks who were not interested in submitting a proposal. So I'm curious to know your all's thoughts on all of this.
Mr. Chairman, would you have me counted present on the roll call?
Yeah, of course. Okay, so we got Mr. Seep and Ms. Glassbrenner both came, so I think we're just missing Ms. Fleming now.
I'm here as well.
Oh, she's here as well. Everyone's here. Okay. So thoughts on the two proposals we received and where we should go with this?
Mr. Chairman,
Yeah.
I think that I would just as soon sacrifice timeliness in favor of no expense to the county in favor of regional planning.
Okay.
Mr. Chairman, I would concur with the chair, being familiar with the work that they did on regional planning the last time, 10 years ago. And I was very impressed with the job they did, and I would agree with the chair. I think it's important for us to keep that relationship with Southwest Regional Planning.
Okay. Thank you, Mr. Seep. Any other thoughts from members of the committee?
I don't disagree with anything that's been said. Really, it's a variance of $113,000 for 6 months worth of time. It doesn't make a lot of sense.
And Mr. Chairman, I can add that I know regional planning is working on staffing right now, so
Okay.
I would think that timetable might be able to be moved up a little.
Well, and we could ask Mr. Maggie because he's on the call here. So do you think that's true, Mr. Maggie?
Yeah, thank you. I was in 3 meetings this morning. I meant to look at was it a late summer date that I provided in that? Is that accurate?
August 31st, 2024.
Yeah, I think we could shave a couple of months off that potentially. We're doing some work already in the county with some public engagement, and we'll have our regional economic development plan that'll be concurrent with this. So there's probably some overlap in public engagement and staffing that would help. Yes. And to Mr. Brewer's point, we're hiring 3 people between now and June. So onboarding is always, stop and go, but yes, we're going to be well prepared.
Now, I thought I had heard that maybe you wouldn't be able to, you'd have to spend the money by a certain date, and that date was before the plan would be completed. Is that correct? Or
We've submitted a no-cost extension request for EDA, and they're usually pretty flexible on this in light of COVID and workforce shortages. We're not the only one who are kind of requesting these no-cost extensions for grants as we come out of COVID and deal with workforce. So that'll actually be what we'll do. We'll just extend the deadline of the grant is the plan.
Mr. Chairman, may I ask Troy a question?
Yeah, go ahead, Mr. Seep.
Troy, I remember when we did the plan 10 or 11 years ago for the county and the townships and the municipalities. Surveys were developed by Southwest Regional Planning and sent out to all the residents. Is that part of your approach again? Survey questions?
It's not. No, I didn't see that request, that level of engagement requested in the scope. It's something that probably with minimal level of effort we could include. I know that the county had asked us to propose how we would engage. We did not propose that route. I like to understand what we want to ask before we push the survey out.
Yes, of course.
There's, in my opinion, room for us all to fine tune the scope of work that you're looking for and come to an agreement on the specifics of outreach. So as we do that, we can explore that.
I don't know the sense of the rest of the committee here. It's just that the question came up previously. I think that's a question for discussion by the committee. Correct, Mr. Chair?
Yeah, we did not put that in our request for proposals that we were requesting a survey be sent out to all the residents.
We found it to be extremely helpful the last time.
Let's see that, I was gonna follow up and ask, so have you all received approval for your extension yet? Or if not, when do you think that's gonna come?
No, I look for it to come here by the end of the month.
Got it. Okay. So we'd know by the next meeting. Okay. And if that extension wouldn't come for some, do you have any reason to think that they won't grant that extension? Sounds like you think they will.
Yeah, our contact at the EDA, I put a phone call into her before I submitted it, and she said that all makes perfect sense.
Got
So
it.
it's a
Great.
confluence of issues that they want to work with us on.
Okay. Okay, thoughts from anyone else who hasn't spoken up yet?
Yeah, this is Bob. So do we have a representative from, both online at all?
Let's see, there's someone named Aaron here, but I don't know who, if they're from both. Just looking to see who the people on their project are.
And just wanted to make sure we were given an opportunity for them to speak. So if the funding doesn't go through, which doesn't sound like it would, be a problem, I guess what would be our alternatives at that point, starting over?
Mr. Chairman,
Yep, go ahead.
we could delay any decision until next meeting, because Troy said he would probably end or know something by the end of this month, so. But I'm quite confident that the funding will be approved on the extension, and that we should go with Southwest Regional Planning, because why reinvent the wheel? They've got so much of this data and information already on hand. They've already started similar projects and are involved. They helped us write our strategic plan. So, to me, it's obvious what way we should go.
And this is Bob again. I guess my suggestion would be that we move forward, with the Southwest Regional, and if we can do pending the grant approval, as a condition, that way if something comes up, then we have that alternative to look at.
Okay, so I think maybe that might be a motion to recommend Southwest Regional Planning Commission as the vendor to the county board pending the grant funding extension requests that they've made.
Yes.
Okay, so it's a motion by Frank. Is there a second to that?
I would like to second.
Okay, second by Ruderstorff.
Yeah,
So,
just a bit of discussion. This is
yes,
Glassberg.
of course. Go ahead, Supervisor Glassburner.
So I'm in favor of that motion. I did want to talk about a couple of things that I noticed in the both plan that I thought were really great. And I was trying to find the particular section and I couldn't find it. But when I had first read through it, I remember that they had mentioned, is it like the 9 points or whatever points that the original plan had taken from the state statute and really organized the plan, the comp plan around. They mentioned that those would be great to utilize and reference in the plan, but that they were going to restructure the plan so that it wasn't laid out in that format. And they had some good reasons for why they would do that. Do you remember that? I can't find it in the document now. But anyways, I appreciated that insight just because I do struggle a little bit with the current layout of the way that the plan is. I don't know that it always flows very intuitively just because of that. I mean, it is very organized because it's very linear, the way it's currently laid out, but I thought they had some good ideas with that. The other thing was obviously, I mean, even looking at their plan, it's very easy to read and engaging. A lot of graphics and just the way that they put the font and everything in there. I mean, again, those are just some details that we could discuss later, but there were things that I noticed that really were good about that, which were things that I think our plan needs in an update. Now, I don't propose that we spend $113,000 to do that, but I did appreciate that in their plan. I wish I could find that section where they talked about reworking the format. Did you find it?
Well,
You have a paper
I have a
copy.
paper copy, which is why I like those. So it makes it easier.
Mr. Chairman,
Yeah, go ahead, Mr. Seep. Well, while they're finding that, we can go ahead.
I appreciate Ingrid's comments. I do not think that this project is as complex or as complicated as we might think it is. We have a comprehensive plan very thoroughly done 10 years ago or so, and all we are really asked to do is update that existing plan. I don't know how many people have read the plan that was put together 10 years ago, but I think that's our baseline, and I think it's simply a matter of updating that plan based upon the changes that have occurred economically, geographically, demographically, so forth. I don't think that this is nearly as challenging or as complicated as the first go around was 10 or 12 years ago. But I think it's important that everybody read the existing comprehensive plan that they produced for us. Whether we have or not, I don't know. They have it in the zoning office, and I'm sure it's in the clerk's office.
Yeah, and actually, Mr. Langreich put it in a folder for the Rules and Strategic Planning Committee as well. So
Okay.
it's on our iPads as well, and we've definitely reviewed it. Supervisor Glassbrenner did a nice review for us a few months back of our existing comprehensive plan. I think if we, we should always be looking at the RFP and the proposal. So what would we actually accomplish? Look at what we asked the vendors to accomplish, and then look at how they responded with what they would accomplish. So that will be our guide for going forward. And to your point, Mr. Seep, we did ask, this was an RFP for a comprehensive plan update. So yes, we're not asking for a total rewrite, but we know that document was 300 some pages, and we're looking for something shorter. I'm sure that's what Southwest Regional Planning Commission, I remember reading in their proposal, that they didn't think we necessarily needed to structure the planning process around the 9 planning elements found in Wisconsin statute. And they had another way of proposing to do that. So this will definitely look like a different plan than that one from 2006, from 16, 17 years ago.
Yeah, I don't think this is a federal project.
This is not a federal project. No, well, actually,
I'm using hyperbole.
Oh, right. Yeah, Mr. Maggie, though, this is federal funding, though.
I understand that.
Mr. Chair,
Yeah. Supervisor Fleming, go ahead.
I am just wondering what the results were from the survey that we all did and completed. What is like a comprehensive or a total scoring comparatively between the two firms?
Yeah, let's go ahead and talk about that. So for folks who did complete the scoring, can someone volunteer to go first to tell us?
Just a total, like, what did Southwest Planning get total as a score from all of us that completed it, and the total score for FOG?
Yeah, did you complete the scoring sheet, Supervisor Fleming?
Yes.
Okay, why don't you go ahead and share what your scores were, and we'll just go around the room and see what, for the folks who did complete it, what their scores were.
For Southwest Regional Planning, the score I gave was 92.
Okay.
Some of the things I made as comments were that I like the fact they included the municipal and township information. I don't know if I missed that in the other one, but they spoke specifically about that. They also included links in there to their other documents, which the other firm did not. It's making it easier to look at some of the plans that they have done otherwise. And of course, theirs was the 8 months longer, but we've already kind of addressed all of that. So for the other firm, I thought their presentation was great as well. I liked a lot of their graphics in there and the digital, project that would be the product. They also had talked about a mixer in there too, as far as the way to, a mind mixer as far as, I think, accumulating data. They didn't have links in there. They did meet the 12 months timeframe, but they got a score of 84 just because they were lacking in some of the places. So, Southwest Planning did get a higher score for me.
Okay, thank you for doing your homework so well, Supervisor Fleming. Much better than me. Who wants to go next? Who else scored and can share their scores with us?
I can go next, and I'm just gonna follow up on my statements from before. So to Troy, I apologize. I was misstating because it was actually in Southwest Regional Planning Commission where they referenced that, because I found in the both plan that they were still gonna have it in the 9 chapters. So that was something that I really appreciated from Southwest Regional Planning Commission, that they're thinking of restructuring the way the current plan is organized. And I like that a lot. I think that that is good. Anyways, as far as scoring goes, I had a score of 80 for Southwest Wisconsin Regional Planning Commission and 65 for both. One of the things that I think is really in favor, I mean, obviously besides budget for Southwest Wisconsin, is because they have a really good understanding of our county and its specific needs, our backgrounds. I mean, they've done so many projects here in the county and have worked with us for so long. So I think they come to it with that advantage of really understanding this area. Obviously, the budget, I did think as the 2 schedules, both had a much more detailed and outlined schedule, and of course was within the time frame that we had asked. The other one was much more basic, and we've already addressed it being a little bit beyond what we're hoping for to have that done, so they did score a little lower on the schedule. One thing that, and I don't know if other people had this problem in the FOAS plan, I couldn't actually access links to their projects, and I didn't have time to go and, I didn't go Google, did anybody look at any of their other projects?
I didn't see any links.
Richland County one I did.
Yeah, but the other one didn't have like accessible links. They had some pictures of their plans, but not accessible links, so. I thought that was kind of a negative, because I would have liked to just quickly peruse some of their previous plans. I think both, you know, they have a lot of background in planning. If you look at their resumes, they had very good resumes and obviously a huge background in a lot of different planning, county, city, and other plans. But then again, so does Southwest. So anyways, those are just some of my thoughts, and overall Southwest scored higher.
Okay, thank you for that. Who wants to go next?
Mr. Chairman,
Yes, Mr. Brewer.
I completed my score sheet, which I cannot find right now. However, it was very much skewed in favor of Southwest Regional Planning. I had them in the 90s, the other firm in the 60s, so.
Okay.
It's about it.
Okay, thank you. Who's next?
I'll go next, but I didn't run off the scoring sheet, but I read the plans. I thought they were both good. I agree with Marty about the money. I am not against Southwest Regional Planning. I think they've done a fine job. I don't think we can afford it. I just always thought they almost know us too well and are almost like a part of us. And it's too bad we didn't get other people bidding on it that would give us an outside view, that would look at us from a different light and maybe give us more insight. So I hope that if we go to a Southwest Planning, that maybe their new employees would have not be so integrated into our current ones, so that they can look at it well.
Okay. Thank you, Supervisor Gentis. Anyone else?
Whenever you're ready for me.
Go ahead.
Mr. Chairman, I feel like the time I was in one-room school and I went up to class with my arithmetic lessons done with my other classmates in a one-room school, and the teacher read the scores. I didn't have my work done, and all I had on my paper was scribbles. she read off the score and she asked us each what our score was. This was in the 3rd grade. Everybody had a high score, and when they got to me, I said 100. She said, "Let me see your paper." I handed it to her, and she made me stand up in front of the whole school. And she came around, turned me over her knee, and spanked the hell out of me. Well, I didn't have an opportunity to score, but I'm totally in agreement with the remarks that have been made so far. I think I couldn't add uh, anything more intelligent than what has already been said. If I said any more, I may detract from what they say. So I'm with you.
Okay, well, thank you. Thanks for your one-room schoolhouse story too. Very entertaining. Okay, anyone else?
I disagree with you. I don't necessarily know the one-room schoolhouse was a good story, having to visualize Don being bent over and spanked. So anyways, I did not score, either, but don't disagree with what's been said so far. But I would like to add that Fo's, proposal was very well put together. And definitely some stimulating things to think about there, as we work towards the new one, so.
Okay, thank you, Supervisor Cosgrove.
So this is,
Anyone else?
Frank then. So I did do the scoring. Couple of things with the Southwest, that came up to me. One was the timeline concern, which I think we've addressed some of that. The other one in the review, in the other relevant projects, they were all related to Richland County, which is good. They're all relevant. I was hoping to see some other similar counties, that were done in a larger scope. And I'm sure they're out there, but I also understand why, they focused on those items that are relevant to Richland County. So, and then working with, the fourth proposal, I thought was very well put together. I did score them a little lower on project understanding, and scope of work, not because only because Southwest, has a better understanding of where we are, and so they got a higher ranking on that. And, yeah, I did appreciate the South Carolina, Richland County, South Carolina, reference in there, which I'm familiar with that county actually. So, in looking at that, reviewing that, it was very good and very accurate. So in the end though, I did, Southwest Regional, ended up with 91, and, the both ended up with 82.
Okay, thank you for that, Supervisor Frank. Anyone else? Okay, so we've had some good discussion. We've already got a motion on the table. The motion is to recommend Southwest Regional Planning Commission to the county board as the vendor to complete our comprehensive plan update pending the grant extension that they've requested. So let's go ahead and have a roll call vote on this, please. Ms. Dahl, if you could take that, that'd be great.
Did you get a second?
Yes, I did get a second. It was from Supervisor Glassbrenner, I believe.
Rudersdorf.
Rudersdorf?
I have Rudersdorf.
Thank you. Thanks for the correction. There's a motion by Frank and a second by Rudersdorf.
So phone call, Glassbrenner,
Aye.
Cosgrove,
Aye.
Brennan,
Aye.
Brewer,
Aye.
Fleming. Aye. Murphy Lopez,
Aye.
Seith,
Aye.
Gentis,
Aye.
Rudersdorf.
Aye.
All voting aye.
Okay, so that motion carries. So thank you for the, I really appreciate all the people who took the time, especially the ones who scored the proposals, but I really appreciate everyone's feedback too. So we'll recommend that to the county board. And then at the next, just to remind us on what our schedule is on this project, just so we're thinking of next steps. Just going to the RFP, this is 06A RFP in our folders. And then if you go to page 7 out of 8, so we have approving vendor selection by the county board on March 21st. So Mr. Maggie, if it's possible to get the answer before the county board meeting, I think that would be helpful. And then we would give a notice to proceed on March 22nd after we approve that resolution to the to Southwest Regional Planning Commission, assuming the county board agrees.
Mr. Murphy Lopez, I'll be out of town for a couple of weeks on a vacation. So
Okay.
I'll be monitoring email. If I get something, I'll forward it, but I may not be able to respond at that window, but I'll endeavor to do so.
Okay. That
May
sounds.
may I ask who's speaking?
That was Mr. Maggie from Southwest Regional Planning Commission.
Thank you.
Okay, so let's go ahead and keep moving on down our agenda then. So agenda item number 7, draft ethics ordinance. So I am going to, actually, I'm not going to share my screen quite yet. I just got to pull up the documents. So we've got 5 documents for this agenda item in our folders. And if you go to the cover sheet, this is, again, a continuation of what we've been working on since last August. And at our last meeting, we made recommendations. This is at the top of page 2 on the cover sheet. We made recommendations for a public property policy. We confirmed which positions are covered by the ethics ordinance, which does include employees, but we called them officials, and then we fleshed out who officials would be. We designated the county board as the appeals body, and then we referred the draft ethics ordinance to Corporation Counsel for his review. So he did complete a review, and let's see, we've got Mr. Wendell, he's on WebEx, correct? Just taking a look here. Yes, I see him on WebEx. He must just not be unmuted at the moment. So if you go, okay, you are now. Okay, great. So we got Mr. Wendell here. So if you go to attachment 07C draft ethics ordinance, so Mr. Wendell was kind enough to go through this and track all of his changes. And I just spent some time on Tuesday going through to give my initial reactions. And so I think if we just go through these and see if there are any objections to the changes and if we need to discuss any of these points in more detail, let's go ahead and do that. And if we need to make edits to the draft ethics ordinance as we're talking, I do have my Word document up on my screen and I can share my screen if we get to that point. But I think for, well, I'll just go ahead and share my screen because I see Clint stopped sharing his screen.
Mr. Chair,
Yes.
if I might just go back a couple of sentences with you.
Sure.
You mentioned the appeal process to the county board from the ethics committee. I have been thinking about that. Those issues generally would be akin to a personnel issue, a personnel problem, and I wonder if it might be appropriate for the appeal to be to the personnel and the personnel committee, rather than having the committee as a whole go through all the dirty laundry that might be associated with it. Handle the appeal in a confidential manner at the personnel level and massage it if you're making recommendations in civil language to send it forward without impugning anybody's reputation too much.
Okay, well, why don't we hold that thought, put that thought on the table till we get later in the ethics ordinance here where we address the appeals?
I think it's a pregnant thought.
Okay, so let's just start here at the top. Mr. Wendell recommended that we establish our authority for creating this ordinance. So he has the Wisconsin statute there. I thought that looked good. Does anyone object to that addition? Okay. Let's see here. His next comment was under the purpose of the Code of Ethics, and it was regarding officials. And he says, I think the intent is for county officials to be the correct term. I found a number of places where the C is not capitalized and may not have caught them all. And I did think about that a little bit, and I think we have uppercase C for county when we're talking about Richland County, or maybe we don't say Richland, but we're referring more to us. But there are some places, like if you look at this top sentence here of section 3A, the proper operation of representative government requires that county officials, so that's kind of more generic. So I think we've got a mix, and I think that mix is okay unless someone wants to get into editing this further. Does anyone object to just leaving them how they are at the moment?
I think your understanding of the grammar is probably correct, though I don't have my book with me.
Okay, I'm not hearing anyone else object, so we'll just keep moving on here. And Mr. Wendell, just jump in at any time if you want to add anything. I'm just going to try to summarize and keep us moving here. So he had some edits at the bottom of page 1 under section 3B. I thought these looked like good edits. I didn't make any comments myself. I thought they were good clarifications. Does anyone object to these edits?
They look good.
Okay, getting some positive feedback, Mr. Wendell. If we go to the top of page 2, so he renamed governing body to the ethics board. And for this section, he thought that it should be defined who the members of the ethics board were appointed by, unless you're planning to either keep the committee structure document as is or amend it to dictate the appointment procedure there. And my comment is I believe we want to keep this section as is, so meaning don't accept Mr. Wendell's edits here because we wanted to amend the committee structure document. And I did go ahead and make that amendment so you could see what that would look like. And if you go to your folders, that would be document 07D, committee structure document. And it's just 2 pages. It's just the responsibilities of this committee. And if you go to page 2 under section B5, right now it says ordinance number 06-28. And if we just strike that language and say that this committee would administer and enforce the code of ethics set forth in ordinance.
Which committee?
The rules and strategic planning.
Oh, yes, yes.
So does anyone object to rejecting these edits right here in this paragraph and just recommending a change to the committee structure document?
So I'm confused. So we're not calling it an ethics board anymore. We'll go back to the governing body.
Let's see. So we would continue to call it the ethics board. Yeah. I'm sorry, you're right, Supervisor Gentis. So in the title here, I don't think there's anything wrong with changing this title. I'm just talking about these changes that Mr. Wendell was recommending in the paragraph underneath the title.
Rejecting the changes and doing it the way we had originally planned will be less complicated.
Well, Mr. Chairman, the ethics committee, after organized legitimately, when it meets, it functions after convening. It functions as a government body.
Yes, it does.
As a board.
So let me just show folks what we would be doing here. So we'd be rejecting that section. So that section would be again down to 1 sentence, and then we'd be accepting this title change. I'm not sure if Mr. Seep objects to that, and we can go back to the governing body instead of ethics board. Don't know if it.
I think leaving it as the ethics board and going back to that original sentence looks like a great idea.
Absolutely.
Okay. Okay, I'm not hearing anyone else object, or no additional thoughts on that one.
So the title is ethics board?
yeah, the title would be, under section 5 would be the ethics board.
Fine, because it's understood that it's a government body.
I think so. Yeah, that's explained in the committee structure document.
Yeah.
And let me just read what the section would be, Mr. Seep, as we've just agreed to here. The ethics board shall carry out this ordinance and shall be a committee of the county board, which has been assigned the duties of the ethics board. Okay, I'll keep moving here if I don't hear anyone else. Under section 6, let's see. Mr. Wendell pointed out that under section 6A, where we talk about closed session, we did say no county official may disclose any information discussed, debated, or acted upon in a closed session of the county board or its standing committees. And he questioned that only standing committees, and I think he's right that we do need to be broader than that. We need to be talking about the county board or its bodies, I guess.
That's right. Any meeting of a government body that is in closed session.
Okay, so I listed committees, boards, and commissions afterwards, since we do go by different names sometimes.
Well, they're government bodies, so that's fine.
Does anyone object to this change here?
No.
Okay. Under financial interest, or wait, let me back up a little here. Oh, under contracts rather. So this would be section 6B. Mr. Wendell, it sounds like you are questioning, you're not sure that the business part of this is enforceable. So we say an official or a business in which an official holds a 10% or greater interest may not enter into a contract with the county involving 15 grand or more a year. And so I was thinking it would be helpful if you research this further. And I think we got that language from Crawford and Sauk counties, their ordinances. And there's some more detail here I got in the comments. I don't know if you had a chance to read that, Mr. Wendell, or if this is the first time you're seeing this.
And my objection here is not the percentage of ownership or anything along those lines. It's specifically that as written, this document purports to govern the conduct of a business which does not necessarily fall under its authority. So by the ethics ordinance, if an official who owned 10% or more of a business entered into a contract with the county, that official would be in violation of the ethics ordinance and could be subject to liability both under this ordinance and under state statute for participating in something in which they had a direct financial interest. I don't think that there's any enforcement mechanism that could be taken against the business itself, because then, theoretically, depending on, say, maybe they only own 12% of the business, but they're the head of contracting or acquisitions or something along those lines, they enter into a contract with Richland County, they being the official, without maybe the rest of the company's knowledge or consent. And then all of a sudden they've subjected the business to some kind of liability under here. And I just don't think that the county board has the authority to dictate that conduct as it relates to a business. So it just either rewriting it or highlighting that it is the official who would be in violation of this ordinance and not the business, if that makes sense.
So do you know how you would reword that to make it fit what you're hoping for?
So an official,
Who owns?
well, it's the 10% mark is accurate. Because again, that triggers the associated, and the state statute uses the language, any organization with which they're associated, and then associated includes that definition of ownership of 10% or more, or holding greater than 10% interest. So an official may not enter into a contract with the county or the formation of a contract or contracts with Richland County involving the receipts or disbursements of more than 15,000 in any year. Additionally, any organization an official may be subject to liability under this ordinance should an organization with which they're associated enter into such a contract.
Makes more sense.
Yeah. That's good.
So like theoretically, I run for county board, I take Chad's seat, I become a county official. If we're discussing contracting with my firm, Ab Swain, I would have a direct financial interest in it. But the firm shouldn't be punished if they wanted to, you know, if I did this in the middle of the current contract, became a member of the county board, I have created a liability for myself because I've created a situation where I have a financial interest in an operation of the board. But the firm shouldn't be punished just because of my actions. Not that I have an ownership interest in the firm. Yeah.
How does that sound? I didn't write exactly what you said, but I wonder if you can just read that and others can read it and see what you think. Do you think that sounds okay, Mr. Wendell?
I do.
Read it out loud too.
Yep.
Okay, I'll just read it out loud just to make sure we're all on the same page. So I just added a sentence. I deleted that part in the first sentence, but then added a second one. Additionally, an official may be subject to this ordinance if they hold 10% or greater interest in an organization which enters into a contract or contracts with the county.
Perfect.
Okay.
And that also puts officials on notice if they, I have an example that comes to mind of someone who ran for public office unaware of these kinds of provisions, ended up in a situation where they almost got themselves charged with a felony because they didn't realize that their ownership interest in something subjected them to these kinds of ethics ordinances.
Okay. Not Richland County, I'm sure. I'm sure it was Vernon County, so. You don't have to comment. Yep, that's okay. So the next section was financial interest, and Mr. Wendell says here, you should consider modifying the language used in state statute to a county official, a member of their immediate family, or to an organization with which the official is associated. And I looked up in statute to see how they defined organization, and it says any corporation, partnership, proprietorship, firm, enterprise, franchise, association, trust, or other legal entity other than an individual or body politic. So this looked good to me. I just was wondering if we should include that definition in our ordinance so that people know what organization means without having to go to statute.
I will note that as the one who is probably going to read this most frequently, but also one who is used to having to refer back to statutes, it doesn't make a difference to me either way, but I would prefer the committee act to make this as informative to the potential subjects rather than fellow attorneys.
Okay.
Mr. Chairman,
Yeah. Yes, Mr. Seep.
perhaps Mr. Wendell could comment on this. Have we decided that all employees are officials, or that all officials are employees? Are they equivalent terms?
Yeah, so we did that under section 4, positions covered,
Yeah.
Mr. Seep. So we say it said this ordinance shall apply to all county officials, whether elected or appointed, paid or unpaid, including members of boards, committees, commissions, department heads, and other county employees.
Mm-hmm.
So it does apply to employees the way we have it written.
Yeah.
So I guess my question here is, and I think, let's see, I think, Mike, what you're saying is we should add language about a member of their immediate family or to an organization in which an official is associated. Is that correct? Are you asking us to add that?
That is correct. That brings it in line with the state statute, which then also is under the authority section. If somebody were confused about the potential definition, they could go back to that statute if need be.
Okay, so I think what we're doing is we're replacing this language, which it looks like you added that edit, but you actually didn't. You just pulled the financial interest definition up, and so you're saying just use this language instead.
Yep.
And then I was just suggesting that we just say an organization is defined as, and then add this part from state statute. Are you all comfortable with doing that, or do you think that's unnecessary to get that definition in there?
No, I think you should have added the definition in there. Definitions are good for people to have a reference to write the document.
Mhm.
Okay. Any objections to that? Not hearing any. Just get our formatting right here. Okay, so the next section was gifts. Looks like Mr. Wendell, you probably just pulled the definition of the gift up. So that's the only change there. And then you had a comment on the nepotism section where we said to refer to the employee handbook. And you said, what about for the board? And then you were thinking of the Vernon County example when there was a county board member whose sister was being considered as a candidate for county administrator, and that board member recused himself from those discussions. So I wasn't sure how we should handle this. The employee handbook only says that generally, and it's a longer section. I've got it here on the screen. You can read most of it at least. That you cannot directly supervise one of your relatives. But we don't handle how that would happen if say we had, say, an opening in our administrator for a department head, and we had someone who was related to that person. So what do folks think about this nepotism thing in the county board?
Well, you're talking mostly about department heads and direct, because we have county board members whose wives or partners work for different agencies. And in a small community, we would not like to rule out all these jobs to so many people. So I think we need to figure out how to do this.
I think you hit the nail on the head with your first statement in that the appropriate role of the county board is oversight, not necessarily direct supervision. And so it would be most relevant to Clint because he then has the authority over the department heads. It was just something that I wanted the committee to consider and possibly to write in a provision along the lines of any direct board or committee action that impacts
I think it's just for the administrator, really, then, is what you're talking about, because the administrator is the only employee that the county board directly oversees. Isn't that correct?
That is correct.
So,
Mr. Chairman.
do we just need to say it that way instead of trying to get too broad? I threw in department heads, but I think I was incorrect because, yeah, we don't oversee department heads.
You could just add a term that the provisions of the nepotism entry in the employee handbook shall apply to members of the county board as it relates to oversight of the county administrator. Again, you don't have to rewrite or reinvent the wheel. You have the language already written out for you. You just have to go look for it.
Mr. Chairman.
Hold on just a second, Mr. Seep.
But it's just gonna be more complicated. Let me throw in another confusion bomb, because that's what I do sometimes. And this is administrative language, so I can think of one other situation, and I think, Julie, we shared this situation when, I think when we entered the session, there was originally an appointment that we maybe had you on
Yes.
the auditorium board. And that is kind of also a position that is kind of quasi, the director is kind of appointed and is responding to the board underneath the current language of that agreement. Now, that agreement is subject to change based on discussions that we're having. But I think maybe that's the only other position, maybe like an economic development too, but that is also subject to amendments right now, in which there's other kind of appointments and direct guidance given from a body. But that might not be relevant because, again, those two are under proposals to amend. Thank you.
Okay, Mr. Seep, go ahead.
Yes, I was thinking about, we allow now, the handbook was changed, we allow a department head to hire subordinate employees. So that rule of nepotism would certainly have to apply in terms of the relationship, brother, sister, so forth, to the department head. And if the administrator is involved, if that hiring process is subject to the approval of the administrator, fine. But if it's not, then there needs to be some other enforcement mechanism. Follow me?
I'm not quite following you, but I wonder if
A department head.
other people did.
I think Supervisor Seep, the mechanism you're talking about already exists in the employee handbook.
Well, that's what I'm wondering.
Yeah, this is so my proposed change cites to that exact provision, which would then govern a department head as an employee and therefore subject to the provisions of the employee handbook.
Very good. So long as there's an enforcement process.
So what this does actually, though, if that situation were to arise where a department head engaged in nepotism, not only would they be subject to the penalties prescribed in the employee handbook, but they would also then potentially be liable under this ordinance as well. So you're kind of double dipping on potential punishments.
That's fine.
Okay, so the sentence we've got added here that Mr. Wendell is recommending is the provisions of nepotism in the employee handbook shall apply to county board members with respect to supervision of the county administrator. Okay, does anyone object to that addition? All right, then we'll keep moving on. So under privileged information, there were just minor formatting changes. Let's see, under advisory opinions, I think maybe we had some more substantial comments from Mr. Wendell here. So he suggested making a change in the second sentence, which was taking out the phrase governed by this ethics code. And he said that that's not in state statute. Basically, any individual can be subject to this, whether we say it or not, in this ethics code. And I read the state statute, and that I was following him and what he was saying there, so it seemed like a good edit to me. Let's see. That takes care of the first and second comments he had under this section. So under the next sentence, It says the applicant shall present their interpretation of the facts at issue and the applicability of provisions of this code before an advisory committee opinion rather is rendered. And he said, isn't this what the person requesting the advisory opinion is requesting from us, like how this code applies to their situation? And he said, I don't want to obligate someone who doesn't feel comfortable making such an interpretation. And I think he's right. We shouldn't include this section because that's our job to figure out how this code applies to their situation. So I was thinking this highlighted section should just be deleted per his recommendation.
Redundant then. Agreed.
I agree.
Okay. This is why we have a corporation counsel to catch things like this.
Yes, we should give him a stipend for this classroom lecture.
I think we do pay him. I hope.
I meant an additional stipend.
Oh, an additional stipend. Well, we'll leave that to the finance committee, I guess.
Give them an attaboy.
We're going to law school here every time we have a meeting.
Yes, we are. Okay, under the complaint procedure, this would be new section 8. He's suggesting that we prepare a person's due process rights ahead of time. I was wondering if those could be prepared and they could be put into the ordinance, because I'm actually personally a little confused about how to explain to someone what their due process rights are. So I don't know if others have thoughts on that, or if Mr. Wendell, you have thoughts on it.
I could prepare that. It's gonna, it might be a more general, what might happen is a general reference to due process rights is included in the provisions of the ordinance. But then with the qualifier that there may be additional rights allotted. The example I'm thinking of off the top of my head is sheriff's deputies have special statutory protections against certain adverse employment actions. And so they have the same due process rights that are established here, but we don't want to make it seem like we're trying to hide other rights that they may have available to them. We want them to know these are the rights that we know every single person subject to this code has, but you may also have additional rights.
I see.
Mr. Chairman?
Yep, go ahead.
Can I affix myself to Mr. Wendell's comments? I have over the years written personnel policies, and that whole process, that whole business of due process, it seems to me, and things maybe have changed, that an employer generally outlines the certain steps that an employee has the right to follow, sort of steps of appeal as a matter of due process, including a right to certain records that are in his personnel file, right to review, the right to well, he has the right to the Fifth Amendment if he's put on the carpet, but the employer has to sort of outline a set of rights in steps in the process of in the disciplinary process, so that it can be demonstrated that the employee was treated fairly. Am I sort of on track, Mr. Wendell?
You are, but I don't believe that is appropriate to include in this ordinance. That would be properly in the employee handbook.
Yes, I
because
agree.
we want those rights to be spelled out, but we also don't want to make them apply generally to positions which we intend to be at will employment, to the extent that we're able to do that. So if we included the due process rights in this ordinance, theoretically that could be interpreted to grant full due process rights to every employee or every county official. And I don't think that's the intent here, but I do think it's proper and good policy to have the disciplinary policy or disciplinary procedure spelled out. And I think the employee handbook has that in there.
And if we have an official that is being investigated, not an employee, do the due process rights that we have listed here, just that they can appeal to the county board, is that basically sufficient?
No. So generally speaking, due process requires a written notice of the charges brought against someone, the evidence that is supporting those charges, and an opportunity to respond. And that can take a couple different forms. In the employment realm, it could be a Loudermill hearing and letter. In this kind of process, it's more of the grievance procedure. So we would, and this is pretty well spelled out in here, but we would provide the subject with written notice, the complaint that was provided to us, an explanation of any additional evidence that supported the claims that were made against them. And then we would schedule a closed session meeting before the ethics board, wherein the subject would have the opportunity to respond. Again, and I'm not saying that the sheriff's deputies are up to anything. They're just an example that I have readily available to me. It's more or less a trial wherein the committee serves as both judge and jury. By default, I would prosecute, and the subject would have the opportunity to have their own counsel, and it would be similar to a court proceeding. We would have the presentation of evidence, the opportunity to call witnesses, opening, closing arguments, et cetera, et cetera.
So I'm just wondering, do we need to just spell that out here, or would you just recommend leaving that out from this? I was just writing notes, but we can take what out. I
would recommend leaving it out, so that way, if we receive a complaint, those don't automatically attach. If it's, I mean, I don't mean to be disparaging, but some crackpot complaint out of nowhere, we don't necessarily want to provide someone a complaint that is completely baseless, that we have no intention of following up on. We don't want to have to worry them.
Right, and we do have that out here in the next sentence. If the ethics board finds probable cause to believe the allegations contained in the complaint shall be referred to a fact-finding hearing. So we have the ability to reject holding a hearing at this point, the way we have it written.
Yeah.
Okay. Okay, so it sounds like we'll be relying on you or whoever's our corporation counsel to be preparing these ahead of time.
Mr. Chairman.
Let me just check and see if anyone else has any thoughts first, and then.
Mr. Chair, this is Supervisor Severson.
Yep, go ahead, Mr. Severson.
So I just wanted to kind of put a background, like we have in my tenure on the county board, my last 8 years, had to do something similar to this over to HHS, where there was some evidence that was presented to a county supervisor, which then led to a closed session, and then the attorneys and then all that stuff. But our labor attorney was involved with this during that time. Is that gonna be something that's gonna happen with this, or is it gonna be Act Swain that's gonna be representing us?
Don't know the answer. I don't believe we specify who would be in a hearing. I think we do refer to the corporation counsel as far as they're the person who should accept the written complaint. We actually say the corporation counsel or the county clerk, but I don't believe we have the corporation counsel specified as having to be in the hearing, nor the labor attorney. I think that's kind of open to each situation, I would imagine. Do you think that's right, Mr. Wendell? Did I get that right?
Yeah. I don't know that it necessarily needs to be spelled out who would be representing the county, and then for the respondents' right to counsel, that would be part of the due process rights that we provide them.
Okay. Anyone else? Or Mr. Severson, did you have a follow-up on that?
I do.
Okay, go ahead, Mr. Seep.
You know, I always have something to say, whether it's worth anything or not. There is a little snag in that representation of where you have a conflict between, for example, our corporation counsel has, upon request, advises our department heads from time to time on a regular basis, as well as our supervisors and our other administrative officials. If there is an allegation against one of those individuals, the question then, say the allegation is by one of the employees against the administrator or someone else. In that case, you have a situation where the corporation counsel is representing the county, but he also has been giving advice to both, and it just happens coincidentally that there's contention between them. And in those cases, I know that we have in the past where we've had those kind of conflicts. We have hired a labor lawyer generally to handle those kinds of complaints and cases. It doesn't happen very often, but it can happen. And so we will run into a little snag once in a while by the corporation counsel representing both the complainant and the defendant.
And I'm just scrolling back up to the provisions of the code. I just want to make it clear that what we're talking about here, there may be personnel issues that the personnel committee still handles, but what the ethics board is specifically tasked with is the following subjects: closed sessions, whether information is shared or not, entering into contracts, financial interest, gifts, nepotism, which may actually just apply to the personnel committee if it's just an employee, privileged information and the sharing of that privileged information, and then public property. And then social media, we just say refer to the social media policy, which may also go to the personnel committee if there's an issue there. So,
Yeah.
So I think those conflicts could come up within those topics, but I don't want us to get too broad here. Our authority is just would be just those subjects if this ordinance passes through the county board.
Well, we would have to deal with those peculiar cases as they come up, on a case by case basis, I suppose.
I think you're right. Okay, so anyone else on that topic? Okay, so Mr. Wendell's next comment was around section 7D, where we said the ethics board may investigate any complaint properly filed. However, no action may be taken on any complaint which is filed more than 1 year after a violation of the ethics code is alleged to have occurred. And he said here, is not investigating a complaint taking action on it. Maybe rephrase the second line to something like, no action will be taken against the subject of such an investigation if the complaint was filed more than 1 year after the allegation, or sorry, rather after the alleged violation of the ethics code. So it looked like a good edit to me. Does anyone object to that edit?
Nope. No.
Okay, so we're just gonna replace the second sentence, what he suggested there. Okay, and then let's see. There was something about how the ethic. It made me think to go back to when he added this reference to Wisconsin Statute 885.01. It did make me think I better go look at that because it says that we can compel the attendance of witnesses and issue subpoenas.
Yeah.
granted to other boards and commissions. And I noticed there that we can also administer oaths. So we can make it very official if we get a serious allegation, and we can require someone to take an oath. And I thought maybe we should add that. So I added that sentence, if that's okay with folks.
That was done 2 years ago by Sauk County. They subpoenaed several county board members to a hearing.
Okay, so does anyone object to that being added, the administering of oaths?
No, I think it's very good.
Okay, and then the last, I believe this is almost the last comment, and it's under, we're still under the investigation, and it has to do with a sentence of, if the ethics board determines that no violation of the code of ethics has occurred, it shall dismiss the complaint, and if requested to do so by the accused, issue a public statement. And he asked us, if everything prior to this point has been confidential, what would the board be issuing a statement on? And I said I wasn't sure, and I wanted to hear what you all thought.
That's why we have a corporation counsel.
Is there a need to issue a public statement? Or can it all stay confidential?
The only thing I could think of for issuing a public statement is to correct an alleged reputational harm. Person X violated, I'm complaining that person X violated this ordinance. Person X is found not to. The board issues a statement saying person X was investigated, no violation was found. But the complaint is confidential, and ideally, everything about the investigation should be confidential as well. And so there shouldn't be any public record of the complaint or the investigation, and therefore a public statement would in fact then put everything out there when it wasn't previously. It also directly conflicts with the potential for the complainant to request anonymity.
Can I speak?
Go ahead, yeah, of course.
So can you issue a public statement if the complaint was found, was unfounded, and the, I forgot the name of the the person who is the complaint would like a public statement done? You understand?
The subject of the investigation?
Yeah.
That's what it says currently. My concern again there, I suppose there's no harm in leaving it in there, so long as the public statements don't contain any identifying information that could lead to an unmasking of a complainant that's requested anonymity. It would be safer not to include that provision, and you could always do it, on a case-by-case basis in the future. There's nothing preventing you from making a public statement, but including it here, that would obligate you.
Mr. Chair, can I ask, did it state prior to this that everything is held confidential? I mean, I hear Mr. Wendell saying that it ideally should be, but when it talks about if we decide to investigate and we hold a hearing, does it, I'm not seeing that it states that that is necessarily confidential.
Or in closed session, correct? I don't think we did state that.
Okay, I couldn't remember.
Mr. Chair, Administrator Lanker, I did have a question for Attorney Wendell too, just to help me clarify on it. That same paragraph is saying that the board shall file written findings and recommendations. I know it's hard to hypothetically guess on every type of situation, but how subject would that document be to open records?
I think there's a section earlier on where we say that things can be revealed if the person grants permission for that.
No, I think I read the advisory opinions paragraph into the complaint procedure. And I don't think that actually applies. I think that that was on me. I misinterpreted that. So in the previous section 7 advisory opinions, the request for an opinion may be confidential. This complaint procedure does not have any confidentiality guarantees in it.
I see.
And so with that in mind, taking that off the table, during the course of an investigation, any employment records or records used that may be used in some kind of proceeding along these lines would be exempt from open records. However, once a disposition is reached, once a decision is made one way or the other, all of those records would then become subject to open records laws. So I actually need to revoke that comment, and I do think then it is appropriate to create that obligation for yourself to put forth the public statement, because then it does protect against that liability to potential reputational harm.
Okay, so we'll resolve that comment there. And then let's see, the last comment, really the real last one this time, is under enforcement, and he is suggesting that we remove corporation counsel from referrals for enforcement. And I took quite a bit of time. I was reading 19.59. I was understanding what you were saying, Mr. Wendell, and it did occur to me that section 1 of statute 19.59, this is where people are entering into contracts that they shouldn't be entering into, I believe, or there's something more higher level that is not necessarily covered by our ordinance. But if that stuff ends up in our lap, it's not up to the corporation counsel to prosecute that stuff. It goes to the district attorney, and if they decline, then the attorney general can take it up. But it's just specific to section 1 of 19.59, and so I included that in our folders just so that people could refer to that if they wanted to. And I was getting confused on this point about referral of things, and I think we're only referring things to the district attorney if that specific part of statute was violated. So that's 07A Wisconsin statute 19.59. And if you just scroll to that section is highlighted in yellow. So does that edit look okay to you, Mr. Wendell? Are you following?
So there are two options here. You could make the edit as presented here. Now, what I meant in my comment is that, and this is in section 3 sub F of the same 19.59, does allow an ordinance such as the one that you're drafting here to carry enforcement penalties. So if you wrote into this ordinance something along the lines of someone found to have violated any of the terms of this ordinance shall be subject to forfeiture not less than $100, not less than $100, not more than $1,000 for each offense, or some number in between that. That would be something that I could prosecute. That would be a civil forfeiture, and that would be properly referred to corporation counsel as enforcement of a civil ordinance. If you choose not to include any enforcement provisions, then you should remove me or my office from this part of the ordinance, because there's not a lot of point in me investigating, or there's no point in referring something to me for enforcement if I don't have anything to enforce. So
we decided not to include the cash punishment or whatever you call, I don't know what to call it.
Forfeiture.
The stuff that forfeiture, we highlight the part I just highlighted here. These are the things we did decide to include previously. So I think those are all things that we can just deliver as an ethics board, correct?
Yes. Yep.
To the county board.
And then the county board can act on it as it sees fit. Yes.
Okay.
I would say then for the edit, I would say if the ethics board believes with SAT 0.59, because then we don't have to, prove that it happened. We just have to show that, there's sufficient information for us to believe that there's that a referral to the DA is warranted.
And it was about accepting gifts. It was about people using their public official office to get financial gain. These are the things in statute that could be referred to the DA.
A lot of reference to what I suspect is Miller Park and Lambeau Field.
There's some exceptions for that stuff, I believe, or there was some sports related stuff in here, but some of it's not sports related. Some of it's just like you can't promise your vote or your influence in exchange for gifts, and some of that stuff does fall under our ordinance, but it also violates this particular part of state statute. So we could refer that stuff to the DA, and the state statute lists it out. You can refer this to the DA. If they don't pick it up, the Attorney General can pick it up. Never brings up Corporation Counsel. So that's why I was just wondering if we should just spell it out. If that section has been violated, we may refer it to the DA for enforcement. So does anyone object to that change right here, including especially Mr. Wendell? I just want to make sure.
No, I have no objection, understanding that the forfeiture had been discussed already.
Okay, and does anyone think I'm remembering that incorrectly? We decided against cash forfeitures, correct?
I don't offhand recall that, but I'm not sure where they would be useful either. Being that we could already censure, suspend, or remove from office.
Okay, anyone else want to
I think
make a case to include those?
Would the cash forfeitures, wouldn't that be a legal enforcement matter, either with a letter from the district attorney? Wouldn't the money go to the clerk of court's office?
It would be a civil forfeiture with the county being the moving party, and I would imagine it would just go to the general fund.
Oh, sure, to the treasurer or clerk.
Okay.
I wanted to ask you about the term "serve without fear or favor." That is a more nuanced term, but sometimes board members sit on a committee, and human nature being what it is, sometimes they are amenable to accepting not gifts but favors, and it puts the employee under that person's supervision in some sort of a bind if that person's ethics standards are strong, or it puts the person in a position where that individual recognizes that this is the way that I can win favors from my board member by providing that board member with a favor. Now, I know that's a very nuanced area, but I also know that it happens from time to time where the county, the department head is in charge of a department where they are in a position to facilitate benefits, funding for projects, for example, the farmers who are sitting on that board. That can be a problem sometimes. How do we deal with that kind of thing? Do we say to somebody, if you're a member of a board, you cannot ask your department head to apply for benefits for you? You will have to go somewhere else and apply for those benefits. You see what I'm saying?
Yeah. So, Mr. Seep, we discussed this when we handled gifts several months ago.
Oh, did we?
Yep, a gift is defined as anything of value. A thing of value, which is any money or property, favor, service, payment, advance, forbearance, loan, etc. If, but I believe it's if it could be reasonably be expected to influence their vote,
Yes.
governmental actions or judgments, or is provided to such official because of their position or office, and could be reasonably considered as a reward for any governmental action or inaction. So it doesn't mean that someone couldn't do a favor for somebody else, but if it can be construed that it would influence their governmental action, say of a department head, or their inaction,
Yeah.
then it could be a violation of this ethics code.
Well, fine. That's a good. That's a very important rule, I think.
Okay. Well, we've already covered that, so I just want to.
Yes. Well, thank you. I don't always read as well as I should.
No, that's okay. No, I'm just reviewing it, and so I think we're at the point now where we've gone through all Mr. Wendell's edits. I don't believe there's anything else that we need to ask him to research now based on this discussion. So I'm wondering if the committee feels comfortable recommending this ordinance to the county board in its current state with all these edits that have been made that are in front of us.
It's a living document.
Well, I think I'm wondering if the committee is comfortable referring it to the county board for their approval, which would make it less living in the sense that we would have to go through the county board to make edits again.
Yeah.
To the ordinance. So I'm wondering if people are comfortable with this as our ordinance we want to recommend.
This is Frank. I was so moved.
I will second that last one.
Okay, so we have motion by Frank to refer this to the county board for approval as edited, and that was seconded by Glassbrenner. Is there discussion on that motion to refer? Okay, hearing no discussion, let's go ahead and take a roll call vote on this, Ms. Dole, if you don't mind.
Roll call vote. Cosgrove.
Aye.
Frank.
Aye.
Brewer.
Aye.
Fleming.
Aye.
Murphy Lopez.
Aye.
Steve.
Aye.
Gentis.
Aye.
Ruderstorm.
Aye.
Glassbrenner.
Aye.
All voting aye.
Okay, so that motion carries. So we'll refer this to the county board for, I believe, the March meeting, if that works for Chair Brewer.
Good discussion.
Yes.
Okay, excellent. Thanks for everyone's work on this epic project that we've been doing. We finally reached the end or very close to it. So agenda item number 8, Public Works and Education Committee responsibilities. So Mr. Brewer requested that this be on the agenda. And this is about maintenance oversight of buildings under both the Public Works and Education Standing Committees. So in your folders, there is a map and list of all the buildings and properties owned by Richland County. That's attachment 08A, County Properties. And this came from Mr. Langreck from his June presentation to the Finance and Personnel Committee. And then attachment B is 08B, Committee Structure Document. I went through it and I highlighted all the committees where there is maintenance of buildings called out. There are some committees where it is called out. For example, the Fair and Recycling Committee, they oversee the maintenance of the county fairgrounds and buildings. The Health and Human Services Committee, similarly, they oversee the maintenance of the Richland County Community Services Building and parking lot. But there are other situations where a committee does not oversee the buildings in the committee structure document. An example of that would be the Joint Ambulance Committee. There's nothing listed there. There might be some other examples too. So we've just got it all in front of us, and I'll hand it off to Chair Brewer.
Seems to me that
Your mic isn't working, Mr. Brewer.
I guess it fell asleep after the last discussion. It seemed,
You can't blame the mic for that.
it seemed to me that the county needs a coherent and strategic way to deal with property and buildings, and not only the day-to-day operation and maintenance of the same, but also a strategy going into next year and beyond. Because we have had several things come up, and one of them is the discussion out at the campus. And I will admit that I have chafed from time to time because we have not, at least in my estimation, come up with a plan for that property. I thought we were well on the way, and then a glimmer of hope was came about with the Save the Campus strategy initiative. And we're engaged in, of course, discussion now with the University of Wisconsin system. And we may well see something happen there. Maybe they won't just walk away. Maybe they'll maintain a presence more than, certainly more than a virtual presence, running something out of a one room in the hall. So in Melville Hall. So the education committee was charged with that task, and I don't know if the education committee, and I don't know, I'm not the last word on this, but I don't know if the education committee was the proper vehicle for that discussion. Education committee to me means they're kind of concerned about education and probably curriculums at the school and maybe the number of faculty, and do we have a recruiter out at the college, those kind of things. But then beyond that, if the university does not come up with a transition plan that is suitable, what are we gonna do with that property out there? It's a valuable property. It's sitting there, basically unused at this point. And I think the taxpayer of the county, et cetera, et cetera, et cetera, has questions for us and expectations of the county board. So I'd like to be ready with answers to the questions that I get. Now, beyond that, it seems to me that we have a lot of, the county owns a lot of property. And what do we want to do with that property? And we don't have a coherent and strategy for doing that. And I'd like to, maybe we need something beyond what is even being proposed here, and we probably do. And it should be part of our strategic planning. But I asked our corp counsel if for instance, the role of the Public Works Committee could be expanded to include that kind of data, that kind of responsibility is the word I'm looking for. If that could be expanded, and he made some suggestions. And I asked Sean to look at committee structure, and then I asked Steve Williamson to come up with language under the his committee structure. So, Mike Wendell, I have a question for you. Has Sean or Steve consulted you in this matter?
They have not.
They have not, okay. Sean has given us a lot of information here. We see that some committees seem to have a responsibility, other committees do not. And I'll ask others to weigh in. I'm not, like I say, the end all, the last word on this, but it is something that concerns me at this time.
Okay, so who wants to share their thoughts on this with the committee?
So in looking at the document 08A, and the page 2 that then does mention additional properties, I'm wondering if we have a comprehensive, a list of the properties. I know the highway department has a number of satellite locations for storage. I know that I'm under the understanding that the county has some parcels that have been sold, that have been taken back as part of tax liens. Do we have that full picture?
I think it was.
Should. That is also properly a function of the Public Works Department, and that does not contain any exception. So the Public Works Public Works Committee. So the Public Works Committee should have or should direct some agency within the county to create what's referred to as a perpetual inventory of the real estate and buildings owned by the county.
Just going to comment. I think it was 2 or 3 years ago that with Public Works, or at the time was Buildings and Grounds Committee, we did have our property lister at that time run a list of everything that's in the property list book on things that are owned by the county. Now you have to imagine now that a majority of them are small little bits and slivers from old highway projects and old road projects and little tiny bits and pieces that are sprinkled across the county. And then the more larger pieces of real estate that you're doing, you're delivering your services from. So that is something that can be pulled from their property lister data. Trying to put it in a manageable type of a report is something we would have to invest some time into doing, as well as then some of them are also broken out, not just county property, but listed by actual highway, or it's Pine Valley. Some of it is also, you know, it's all one legal entity, but we do have it with different names and quasi entities on the property book as well.
Okay, anyone else with thoughts?
Is this something that falls into a comprehensive plan? Is this something we need to make sure that we're looking at into the 3-5 year window? Is that the idea?
Well, I think certainly it's part of the planning, future planning, but also day to day. I mean, we make decisions every day for the courthouse, for instance. Decisions are made across the street from that building. I see Supervisor Stevenson and a mic, perhaps he can share a comment.
Go ahead, Mr. Chair.
Yes, absolutely. Go ahead.
When I was on the comprehensive committee or strategic planning committee before we did this restructuring, I think that we thought it would be good for the county to have a maintenance department. And I think that we included that in there. And I think that's what I envision you is that you're wanting, Chair Brewer, is like a maintenance department that would oversee. Because right now, how many air conditioners do we have, or how many furnaces do we have in all of our county buildings? I mean, nobody knows. And so we go to our committee meetings, and like at HHS, they got like 6 air conditioners or heaters over there. And you come over here and there's 13 of them, but then one contracts with Works to do another one, the other one does Strang, and we're all over the place. We don't have the years that they've been replaced. And if we had a maintenance department or somebody that overseen that, that's where we could possibly find some good relative function. But as far as like day to day, like if somebody wanted to donate money on the fairgrounds to put lights up in a building, I don't think that it needs to go through 3 committees. It should just go through like let the fair take care of their own buildings, let the parks take care of their own building. the campus has something that they wanna put a flower garden up, like, let them put that out there, like, let that committee decide that, but as far as like the generalized maintenance of stuff, like the hot water heaters and furnaces, air conditioners, roof repairs, let's have just one maintenance department that oversees all that stuff.
And Mr. Langrick, this is, I'm just opening up the 5-year financial plan. We do have it programmed in there to have an addition of a maintenance director in the year 2027. It's a $97,000 cost, and it says combined maintenance services and oversight on county facilities and operations. Does that all sound right, Mr. Langer?
Does, I think it's also put in the strategic plan as one of the functions to centralize.
Can I speak?
Go ahead, Supervisor Gentis. Yeah.
I like what Supervisor Severson's talking about. I think that is an excellent idea, having sat on HHS and other boards where we're dealing with all the different things, and at the campus too, because we may have some changes, and we don't have maybe that many people on the county board that are really that versed in the boilers, the HVACs, and all those things. I see that the property committee can give advice, which I think is an excellent idea. And I think we should actually start using that advice when we need it. But it would be good if we could move quicker to some sort of a maintenance. And I like the idea of coordinating, organizing, getting budget, getting, sending out bids. I think that is a much better situation.
And then just to read what Supervisor Gentis was referring to. So right now, the Public Works Committee provides oversight and advice regarding the operation, maintenance, and janitor service of all county buildings not specifically assigned by statutes or by action of the board to other agencies or departments in the county. I think that's what you were reading from?
Yes.
Okay.
I'm not quite sure when it says not by statute, so maybe they can't give us advice if we need it. I'm not quite sure.
Well, I think like the parks function, I don't think it's listed that they're in charge of their buildings on park property, but I think it refers to statute. And I bet the statute says that the Parks Committee is in charge, the Parks Commission is in charge of all those buildings. So I think that's maybe what that refers to, but.
Mr. Chairman,
Yeah, go ahead.
I'm thinking of, how about the Ash Creek Forest? Who's in charge of that?
Land conservation.
Land conservation. Should land conservation have the ability to sell Ash Creek Forest?
They can, my opinion, Mr. Chair, Supervisor Severson, that they have the ability to explore that, but it ultimately comes down to the county board, whether they want to sell it or not.
Well, absolutely. But would they negotiate then for the sale of Ash Creek Forest and then bring a proposal to the county board? How would that work?
Assume that's how it would go.
Well, I'm just using that. I'm not in favor of selling Ash Creek Forest, but just as an example.
Your sale of land, the template that we're currently using most often is through like tax deed property. And then your sale of that property is a action by Public Works to recommend the sale at this much of a price, and then it arrives then in finance and personnel for an auction with the proper posting is kind of the vehicle that's used as of right now. Other situations to kind of where this is hitting at the present is, say, like an example, there's a small parcel at Keysville that's currently underneath the highway. It's been identified as a possible green field, not field, green field site for a radio tower county build there. So working with highway commissioner was conversation on, well, do you need this and use this? It's sold right away from a project that has been completed. He said, no, we don't have use for it. It can be reappropriated for that. So that's kind of another situation now where it's currently written in the deed as like highway, Richland County highway property. But as soon as we put a tower in there, I mean, should that really fall then in the highways purview of taking care of that piece versus transitioning over to like a public works now because we're gonna have a radio tower on it or to a public safety or those types of elements.
It's almost like that property that's there by Pine Valley that's, says if you look on the GIS map, it says Pine Valley Farm, Manor, Richland County, but then the parks would like to utilize that property to make that into an open space for recreation. But Pine Valley's got the governance over it right now, I think, correct? Actually, the county does as a whole. Have it, but it says Pine Valley.
But Carrie, and I would, I don't see, I'm on the Pine Valley, committee board. And I don't see us discussing that at a meeting. Should we turn this property over to, so-and-so? Should we develop it as a park? I don't see that happening, right? Under our present structure.
But I think coming back around to where we were a few years back, I think the vision at that time was inventory of all the properties and almost treating it like we do with, say, like our building policy, where you build a policy and then you have a map of your floors and you're identifying which department has authority and responsibility over those rooms and hallways within your little building. Same thing across the county of identifying all your little parcels and re-identifying and reiterating who has authority over each parcel, and then defining out in language different types of stipulations and authorities then you have for your different bodies and what, again, what authorities and responsibilities you want to delegate down to those folks. So I don't know if that clarifies anything, but.
This sounds more like a real estate identification and responsibility initially than it does a maintenance of those properties.
Well, I think it's both things, Bob.
Okay.
I believe. One of the things that struck me, first day on the county board, I attended a meeting of the UW extension, and we spent 45 minutes debating buying a copier. Should we lease it? Should we buy it? And I'm thinking, what in the hell's going on here? Doesn't the county have a policy regarding copiers? But no, we don't. So that kind of property, maybe I'm getting off course here a little bit, but,
Well, and I just want to mention too that right now the Public Works Committee, under this section that's highlighted that I put on the screen, already has the authority to provide oversight and advice regarding utilization and repair policies of all public lands, buildings, recreation sites, access sites, inclusive of all short-term public holdings of the county. So I think there are situations like Pine Valley, where, Pine Valley, also in the committee structure document, they're in charge of all the buildings, but there may be some overlap sometimes between the committees, and maybe it needs to be separated out more, but Public Works already has some authority to provide oversight and advice, say, of that land across from Pine Valley, the 40 acres. But that's what this committee's role is, to figure out how to sort out these responsibilities. And if something needs to change, we can change it. And there are inconsistencies right now. It's pretty clear in the committee structure document. But it's also, in my opinion, kind of tough to do without a staff person who is going to basically be the maintenance building person if we're talking about buildings and not land.
Mr. Chairman.
Yep, Mr. C.
With regard to the public land, we, especially with the parks and the forest in Pine Valley, we have to know the history, how those pieces of property were acquired, whether they were donated with restrictions, I know of two entities that are county park property that if the county should try to sell the land or use it for any other purpose than a park for which it was donated, it must revert back to the original donor or his or her heirs. So that may well be the case with the Aiken Forest, and might be well be the case with the Smart Farm. Those properties generally have strings attached when they're donated that we have to be careful about. So the Public Works Committee needs to be cognizant of the fact that the deeds of these properties, they were deeded over to the county or conveyed to the county by lease or whatever. The park in Rockbridge, for example, the south end of it is a perpetual lease, subject to expiration if no longer used as a park. So it's important that Public Works be aware of the need to not jump the gun on trying to sell properties without being aware of those restrictions on the property. I don't mean to sermonize, but it worries me.
Don, Simons would be another. property.
Simons as well, right? Simons was donated with restrictions.
Mr. Chair,
Yes.
may I ask Corp Counsel to weigh in on this? I know he's not a policymaker, but he does assist us in trying to set policy.
And I can advise you when I think a policy is a wise idea, which I agree with here. So from the discussions, I think there are two separate issues that need to be decided on. One being the day-to-day maintenance of county buildings and property. And it is harder to do that without a staff member, someone centralized person whose job it is to understand and keep a mental inventory of all the little foibles. I know Vernon has Phil Hewitt, who's their highway commissioner, but also their buildings and facilities manager, or whatever his title is. But then there's also the utilization, I think, is a good term, because selling a building is also utilizing a building. And what has happened with the developments with the campus, for example, the removal of East Hall that the board just voted on. Well, according to the committee structure, the education committee has authority over East Hall until it is no longer subject to the UW campus agreement, per the terms of the committee structure. So if we were trying to determine what to do with East Hall, the question has arisen, this is not a hypothetical, the question has arisen as to which committee has that authority. Because can the education committee negotiate some plan or arrangement for a building that it will immediately lose the ability to implement? And if I were a party that were entered into negotiations with the committee, then I would be very hesitant if I were to find out that the people I'm sitting across the table from, as soon as we strike a deal, will not be the people who actually sign the contract. And so when Chair Brewer approached me about this, I did recommend that there be the implementation of some kind of policy. And the simplest solution in my mind is simply to create some ordinance or possibly an amendment to the committee structure stating that if a building or property is subject to the exception found in section 1 EA, and an action is being taken or considered which would no longer subject it to that exception, that a committee, the Public Works Committee, by default, assumes responsibility even prior to the removal of that authorization. So, you just voted on the East Hall removal. that was a function of the education committee. Should the policy that I'm suggesting be implemented, that would have been, once the UW president put out his demand to terminate in-person learning, and we started exploring alternate uses of the campus, then the Public Works Committee either should have taken charge of that effort or at least had some authority to act with the understanding that if the proposed use of those buildings no longer subjected it to the exceptions, they would immediately assume that authority. An alternative potentially could be the creation by default of an ad hoc committee between the committee that currently has responsibility over the building and the Public Works Committee. I think that would be overcomplicating things, but it would ensure that the committee who's had oversight over this building or this property for however long they've had oversight would have some input on how it is eventually disposed of. That was kind of a rant. So,
Mr. Brewer, do you propose that we do anything today? It's already afternoon here, and we still got one more agenda item, so I want to keep moving too.
Who are you asking, Sean?
I'm asking you if you want to propose any action today.
Today, but let's not let this drop, however. And I urge, I guess you, and I can be involved in working with Mike Wendell to come up with language that would do streamline, make possible the very thing we're talking about. East Hall is only one example, I'm sure. There will be more in the future, not only with the campus, but with all county property.
Okay, so yeah, I'm not sure if you're making a motion or if you're just encouraging further discussion. I'm not.
For a motion yet, I think that we need to leave this on the agenda and revisit next meeting. In the meantime, we can do perhaps even have language available to review for amendments.
So are you making a motion to have Mr. Wendell develop language and return to the committee with that draft language?
Yes. If that's what we need to do, I'll make that motion, yes.
Okay. So we got a motion by Brewer. Is there a second to that?
I'll second on this committee.
I thought he was going for
Who's the second? Cosgrove?
Yes.
Okay. So discussion on that motion?
I think I agree that we should be doing something. I think it's too early to have him write something up until we figure out the maintenance person. And there's just a lot of things we need to discuss and try to get in order so that he could write something up.
I'll just jump in and say the creation of a maintenance supervisor and or department is far beyond my purview. I would exclusively be developing language of the transition policy, for lack of a better term.
I guess my position on this is I think, take East Hall as an example. It's covered by the agreement. Once that agreement is amended with the Board of Regents, then that building would no longer fall under the purview of the Education Committee. With the way we have everything written right now, it would fall under the purview of the Public Works Committee. So in my mind, say that agreement gets amended this summer, after the negotiations are finished, say it gets amended in July as an example. At that point, East Hall shifts from the Education Committee to the Public Works Committee. So I guess I don't really see a need to develop a policy when we already have language that would basically transfer East Hall to the Public Works Committee. I guess that's why I'm against having Mr. Wendell develop language at this point.
Can I
Your thoughts?
I
Can
think
I
it needs,
jump in here?
Yeah, go ahead.
Sorry.
Supervisor Rudersdorf.
I'm also, I think, against having anything written up. I think we need a lot more discussion first as far as what needs to be addressed in that. And as far as yeah, selling properties, and thinking along the lines of parks, we also have so many easements and things like that. So, you know, as far as selling certain properties, I mean, I think there's a lot more to consider than just, okay, it's switching hands. So that makes
Thank you. Anyone else?
I think that we should ask Mike to take a shot at this. We'll bring language to a next meeting, and then we can have a discussion and a vote. All we're doing right now is asking that that be done.
Okay, anyone else? Okay, let's go ahead and take a vote. And Ms. Dahl, if you could do a roll call on this one, that'd be great. And this is a motion to have Mr. Wendell develop language about transition of buildings and lands from one committee to another in the cases he was referring to.
Mr. Chair, before the vote is called, in the interest of providing thorough counsel and advice, which is my duty, I do need to point out that a motion or action by a board or committee is not necessary for a supervisor to direct me to craft a resolution or ordinance. I appreciate the exercise in democracy that is represented by that. It's happened a couple of times in the education committee, but just so everyone is aware, because it's come up a couple of times now, Rule 19 of the rules of the board does allow any supervisor to direct corporation counsel to prepare a proposed resolution or ordinance.
But that's doesn't go through a committee. That goes directly to the county board under our county board rules. Correct?
Mr. Chairman.
Mr. Wendell, is that correct?
The context of it is in the agenda items section of the rules of the board. My reading of it, though, it's a standalone sentence, and my understanding of it has always been, and please correct me if I'm wrong, because I don't want to put myself in a scenario where I'm acting directly contrary to the intent of the board. But the plain reading of that sentence is that any supervisor can direct me to prepare a resolution or ordinance so long as they're comfortable with their identity being public information.
Also, it says further, this is Rule 19. Any supervisor may direct the corporation counsel to prepare a proposed resolution or ordinance, but the identity of that supervisor shall be public information. No resolution or ordinance shall be brought to the consideration of the board unless it has been signed by a majority of the members of the appropriate committee. Upon signing a proposed resolution or ordinance, members may indicate on the resolution or ordinance their position, for or against.
Mr. Chairman, that's correct. And all of the members of the committee can vote no in opposition to the resolution, and it still can come to the board for consideration. Their no does not negate or stand in the way of that resolution coming before the board.
And I think the motion that
is an expression to the board that they are opposed to the resolution.
Yeah, the motion before us right now is to direct the corporation counsel to develop language that would address this policy. I don't know that, Mr. Brewer, were you asking in this motion for him to develop a resolution?
Well, apparently I can, if I want to.
Yeah, it sounds like you can. You can direct him. You can direct him to prepare a resolution.
I would
imagine that the resolution would need to include editing of the committee structure document. Although Mr. Wendell was saying something about developing a policy, now that sounds different than the committee structure document. So I'm not quite sure. To me, the motion sounds like it's language developing a policy, which isn't a resolution. So it's getting a little confusing here, but I just think, yeah, there are ways around it if you want to just have him do it. If, if the vote doesn't go through committee here.
I think ultimately the board can, you can take a resolution to the board and the board can overrule any rule or ordinance.
You can suspend a rule. Yeah, you can suspend the rules. That's correct.
Mr. Chair,
Yeah.
the reason that I asked you and Mr. Williamson to consider this was my desire to work this through committees and have committees bring the language forward for board consideration. And apparently, nothing was done with park council to that end. So we're back at square one as far as I'm concerned. And I guess I will ask then Mike Wendell to develop language that will accomplish what I want accomplished.
Okay, well, let's just see if you have the committee's backing here. So Ms. Dole, if you could just do a roll call vote, that'd be great.
May I ask before you do the roll call vote? Does that
Yes.
mean that this resolution will establish a premise upon which conversations will be based regarding this whole subject?
Wait, this is not a resolution, right?
No, well, yes, he's bringing a resolution before the board. He can do that.
No, I don't think that's what he intended.
He's going to direct Mr. Wendell to prepare a resolution for the board.
That's not in the motion, Mr. Seep. It's just developing language regarding this policy.
Oh, okay. I'm sorry.
Yeah, and it does say in our county board rules, Rule 19, no resolution shall be brought to the consideration of the board unless it has been signed by a majority of the members of the appropriate committee.
But they can sign it no. It has been done in the past several times.
I'm not quite sure how it's been done under Rule 19 because folks just got to go and read the rule. Any supervisor may direct the corporation council to prepare a proposed resolution or ordinance, but it doesn't say that that proposed resolution goes right to the county board. It says that it cannot be brought to the county board unless it's been signed by a majority of the members of the appropriate committee.
That's correct.
Mr. Chair, if I might suggest, we carry through with the vote on the motion that's on the floor and then enter discussion of this rule as a future agenda item. I think this discussion has made it clear that there needs to be some clarification on this. Again, I do not want to be acting contrary to the interests of the board, but that is my interpretation of the rule as written.
Okay, let's go ahead and do a roll call. Ms. Dole?
Frank,
Yes.
Brewer,
Yes.
Fleming,
Yes.
Murphy Lopez,
No.
Seat,
I will vote yes. I don't mind.
Okay, go ahead. Keep going. We don't need explanations. We got to keep going.
Jentis,
No,
Rudersdorf,
Yes.
Glassbrenner,
Yes.
Cosgrove,
Yes.
7 voting yes, 2 noes.
Okay, so that motion carries. So we'll have Mr. Wendell develop language, and then we'll have that back at the next committee meeting. So agenda item number. Oh, I'm sorry. Sorry, I lost my agenda here. Yeah, thank you. Agenda item number 9, committee structure reorganization check-in. So Mr. Brewer mentioned that Mr. Severson brought this up at the last county board meeting and wanted to do a check-in on how the reorganization of the county board's committees has gone. So I'll go ahead and hand it off to Mr. Brewer or Mr. Severson to kick off the conversation here.
Well, I'll defer to Kerry if he's ready to speak.
Thank you, Mr. Chair. I guess what I come down, what I was thinking, I believe that in good function of government and like good business practices, even though my theory of like running county government as a business is not what I agree with, but, we did a major overhaul of the way that we do county government within the county. And we did that within 3 months last year, from January until basically March, right before county board, before the election, we finalized and we restructured, and now we've done nothing with it to see how well it's working. You know, the restructuring was led to believe by the famed, La Crosse and Ozaki counties, how efficient that they were, how streamlined things were getting done, and how short the meetings would be. So we got this, I think now it's just time to review that we're almost a year into having this reorganization. Like, where are we struggling at, as far as like trying to be efficient, as far as streamlining, as far as having meetings run shorter, like they were led to believe that that's why we needed to pass this. So I think that it's good business practice to review something that we implemented and see how we can make it better. If this is what we're gonna continue doing.
Okay, Sean, may I speak?
Yeah, of course. Yeah, go ahead.
After hearing your concerns, Carrie, and sharing some of those concerns, certainly, I talked to Chairman Sean Murphy Lopez, and we agree this probably has to be done, but we're probably about a year early on it, because probably it would be more appropriate to give this a few more months, and the whole board will be reorganized next April. And probably at that time or prior to that, this discussion probably should commence, but that's my thought on it at this point. I agree with Sean on this one.
Mr. Chair, can I speak?
Yeah, of course. Go ahead.
I don't necessarily disagree with Mr. Brewer. However, I do think that it would be valuable, particularly for members of the board who had sat under the previous structure and now have been operating in the reorganization. I mean, I think we should hear from the entire board, but particularly there's been some members who have seen both, right? And I think that Mr. Severson has a really good point. I don't think that it's necessarily too early for a check-in. I think it's maybe a little too early for any types of judgments to be made, but I would certainly like to have a check-in and some thoughts on this prior to the reorganization next April.
Well, let's just go ahead and why don't we just go around the room with people who have been on the board previous to the reorganization, and let's just do a check-in. Let's just get initial thoughts. So can you just share your thoughts, and then we'll just go around the room?
Yeah, I mean, I'd be happy to do that, but I think it needs to be broader than just this committee.
Oh, you're suggesting we do it at the full county board?
I'm suggesting like a poll, for example, or a survey or some sort of doodle thing, and specifically addressing the various areas that we changed. You know, the different committee structures, the combining of committees, the way that people are appointed to committees, the roles of the chairman and the vice chair, et cetera. I think those need to be highlighted. We need to have specific questions for each of them and have opportunities for every board member to give input on that.
Got it. I see.
Department heads too.
That's exactly department heads, yeah.
Yes,
The department heads need to be included in this too, because we altered how they are doing stuff now too.
and the county administrator.
Plus that way you get a bigger perspective or a much more broad perspective, even though the people that are on the board now may have not been on the old version, there still may be things that they're experiencing that we should discuss as well.
Agreed.
I totally agree with Ingrid and Carrie. I think we should start.
Okay, so I wonder if maybe what would be most helpful is if this committee approved a survey that would go out to the entire county board. So we develop a survey and then send it out to the whole county board, so we could work on a survey and have that on our agenda next month and then get that issued.
Mr. Chairman?
Mr. Severson and then Mr. Seep.
I would would defer to Mr. Frank. He, wanted to speak.
Was it Mr. Frank? Sorry, Mr. Frank and then Mr. Seat.
I just would recommend the county board members, but also the department heads and working through with Clint on that, because that's, in the end, that's really who we're trying to improve is how the process works, not just for us, but for the entire county.
Did I say a survey for the county board? Yeah, okay. You're adding department heads and,
Yes.
sorry. That's a good clarification. Mr. Seat?
Yes, I think some of these committees that have been melded together into a standing committee, some work better than others. Some meld better than others. Some are rather awkward. I know of one particular committee that 90% of the time in the meeting is devoted to one part of the committee, and the other committee that's joined has generally an average of 5 minutes to participate, 10 at the most. And therefore, the purposes of the one joining committee, as it previously operated, are quite diluted, and the scrutiny over the monitoring of the budget and the department operations has completely eviscerated. So there's a lot of disenchantment and unhappiness by the small committee that's been joined, because it is sort of like a divorce. It no longer can meet with its previous department head. So consequently, I think it's room for discussion, but I believe Ingrid is right. There needs to be discussion, but I think we should have that discussion at the committee level first. The two parts or the three parts ought to sit down with one another and say, well, how is this working out and what can we do to make it work better? Before we involve a big survey of everybody, let's deal with one committee at a time. I don't think all that there's problems with all of the combinations of committees, but in my reference to one particular committee combination, there's a lot of unhappiness, and there's an inability to express it for the sake of maintaining the harmony of the whole committee. And it's not a criticism of any one individual, it's just the way it's structured.
Okay, so we've got some different ideas out there. Supervisor Glassbrenner, you were the first one who brought up the idea of a survey going out. Would you be open to making that into a motion so that we can figure out what we're actually doing here?
Sure, I'll make a motion. I was worried you were gonna like ask me to develop the survey, but then I was gonna be like, oh no.
Well, you might have to, but we can discuss that here. So go ahead and state your motion, please.
Okay, hold on. So we had some discussion after that, though, that would take place at this committee level. So I guess I'm a little confused as to what motion I'm making.
Yeah, that's what we need to do as a group. We need to decide what we're doing. There's some different ideas out there. You know, I think, why don't you just put out your best idea out there and let's debate it and vote on it. I can't hear you. Your mic must have stopped working.
You know?
No.
How about now?
Perfect. Thank you.
So a motion that the committee would work on developing a survey regarding the reorganization changes that took place last year. That would then be sent out to the county board and department heads. Does that sound, anybody want to change that?
Okay, so we got a motion by Supervisor Glassbrenner. Anyone want to second that?
I'll second.
Second by Rudersdorf. So any discussion on that motion that she made? The motion would be that the
I'll
committee.
just say something. I think we can still go have something else where we ask each committee to have a discussion as well as a survey too. I'm not making that a motion. We can, because we might talk about this again next month.
I
Sure.
was gonna say maybe that could be on the next agenda.
Mr. Chairman,
Yep, Mr. Brewer.
I like Ingrid's motion, but she didn't say who was going to develop the survey.
This committee.
This committee. And
Well, and we'll need someone to put a first draft together. So we, sometimes that gets hashed out behind the scenes. We don't need to hash it out today. We had a long meeting already. But just that the committee believes that a survey should be developed. I think that's what we're debating here and what we'll vote on.
Cheryl, so I liked her.
Anyone else? Okay, so the motion is to develop, to have this committee develop a survey to go out to, did you say, Ingrid, county board and department heads or something like that?
The county, the department heads are not committee members. This is county
Supervisor
government.
Glassbrenner, what did you say? Can you repeat
The
that?
department heads are not county board committee members.
Okay, Mr. Seep, I understand. I'm asking Ms. Glassbrenner what she said.
The survey would then be sent out to the county board and department heads, but I would also like to include county administrator in that as well.
Okay. Okay, so it's a motion that the committee develop a survey that will go out to county board members, department heads, and the county administrator. So Ms. Dole, if you could do a roll call on this, that'd be great.
Brewer,
Yes.
Fleming,
Yes.
Murphy Lopez,
Yes.
Seek,
Yes,
Janice,
Yes,
Wiersdorf,
Yes.
Glassbrenner,
Yes.
Cosgrove,
Yes.
Frank,
Yes.
all voting aye.
Okay, thank you, Ms. Dole. So we'll get to work on developing a survey, and that'll come back to this committee. Agenda item number 10, future agenda items. Does anyone have any future agenda items that we haven't already taken some action on today?
we have a lot of them.
I would ask the committee to consider development of a policy for utilization of corporation counsel services.
Good call.
Valid.
Good topic.
Okay. Anyone else? Okay. Agenda item number 11. So I'm looking for a motion to adjourn to, let's look at our calendars here. This would be into April. The first Thursday in April is April 6th. So a motion to adjourn to Thursday, April 6th at 10 a.m.
I move, Linda Janice.
Motion by Gentis,
I'll second.
second by Fleming. All those in favor say aye.
Aye.
Those say no. We're adjourned. Thanks, everybody. Have a great day. Thanks for all the good discussion.